One of the vendors that our law firm works with asked me today if we do civil rights law, and I said we do. And then she admitted that she didn't really know what that meant. She kind of understood generally that it involved, probably suing the police sometimes, but beyond that, didn't really know. And so I thought we'd make this video to kind of explain what civil rights law is, what a civil rights lawyer does, and examples of civil rights lawsuits. And the key point is that civil rights involves a government defendant, right? It's not a private individual that did something to you, although it can be in very rare circumstances if that person is working with government actors. But there's always going to be some sort of governmental entity or governmental actor in the frame. So a classic example is excessive force cases, suing a police officer or a law enforcement agency for excessive force. Think of the George Floyd case, and we're handling several of these types of cases right now. And so just to go with that example, the way that that lawsuit works is you have a constitutional right. In this case, it's the Fourth Amendment right to be free from unreasonable searches and seizures. And so anytime law enforcement uses too much force, that's an unreasonable seizure under the Fourth Amendment. And you are able to vindicate your rights under the Fourth Amendment or any constitutional right that you have through a statute called 42 U.S.C. 1983. And you'll hear this term thrown around a lot, 1983 lawsuits. That's what it means. I'll put the text of this statute up on the screen now, but essentially 42 U.S.C. 1983 allows you to go to court to vindicate your constitutional rights. In an excessive force case, as I've said, that's the Fourth Amendment. It could be something else. It could be the 14th Amendment. For example, a malicious prosecution case, which we've handled. Let's say that the government fabricates evidence against you and initiates a prosecution that should never have occurred. Now you have the 14th Amendment guarantee to due process, and you're going to go to court through the same mechanism. You're going to use 42 U.S.C. 1983, and you're going to bring a malicious prosecution or possibly a Brady violation type claim against those entities. But in both examples that we've discussed so far, excessive force and malicious prosecution, the defendant is going to be someone in the government, whether that is an investigating police officer, an arresting officer, someone like that. You can go after them through these mechanisms we're talking about. Another example of a civil rights case involves what we call equal protection violations. That's also guaranteed under the 14th Amendment, which prohibits discrimination and provides for equal protection of the laws. These are usually in the context of discrimination, but there are often also specific statutes prohibiting, for example, discrimination on the basis of sex. That would be Title VII. On the basis of race, that would be Title VI. And on the basis of sex and education, that would be Title IX, and on and on. So there are, different protections that you have under the federal congressional laws or congressional statutes. And you may have a cause of action specifically under those statutes as opposed to just 42 U.S.C. 1983. So, depending on what the situation is and what the misconduct is, whether that's a due process or force or some sort of discrimination, it's going to control how you bring that claim to court. Now, what's a little strange in this area of 42 U.S.C. 1983 lawsuits is that the state law provides a lot of the gaps in the federal law. What does that mean? Well, specifically the statute of limitations, which is a key thing, right? It's how much time you have to bring your case. The federal law looks to the state law where the claim is being brought. So what does that mean? It means that if you were the victim of excessive force in, say, the state of Tennessee, you have 1 year to bring your case. Why? Because Tennessee has a 1-year statute of limitations for personal injury. But if you were in some different state that has a 2 or 3 year personal injury statute of limitations, then you get 2 or 3 years to bring it. It just depends on where you are. So it doesn't make a whole lot of sense that there isn't just one federal statute of limitations for excessive force, but there isn't. There are actually 50 different ones, depending, maybe more than that if you were in one of the territories or something like that. But the point being that there are still some gaps in the federal common law that are filled in by the law of the state in which you are bringing the claim. This is why it's actually important, if you have a federal civil rights case, you wouldn't necessarily think that the state law would matter that much, but it might. And so you might want to consult with a local lawyer in the state where you might bring a civil rights case. Now, to talk a little bit about the damages that you can get under 1983 cases, one of the nice things about these cases is that there is not a cap on the recovery. There's no federal civil rights cap on 1983 damages. Some statutes, even federal statutes that are technically civil rights statutes, like, for example, Title VII, which prohibits sex discrimination in employment, have statutory caps on the most you can recover for certain things. No such caps in a 1983 case, which is why you see, for example, huge numbers like the George Floyd case. There have been others out there for these big numbers. It's because there's theoretically no limit, and that is a good thing in terms of holding the government accountable for misconduct. You can also get your attorney's fees if you are what's called the prevailing party in a civil rights lawsuit. Now, this has just been made more complicated by the current Supreme Court making this video in 2025, and the current law is that, basically to be a prevailing party, you almost have to win the case all the way at trial. So just getting a preliminary injunction, for example, is no longer good enough. But the idea behind allowing civil rights plaintiffs to recover their attorney's fees if they win is so that lawyers will be incentivized to vindicate constitutional rights and curb government misconduct, even if it's not a super profitable situation. And I'll give you an example that illustrates this. There was a case here in Tennessee where a police officer stopped a family on the interstate, and during the traffic stop, the family dog got out of the car and started running away, and for some unknown reason, the police officer shot the family dog in front of the family, which included young children. That's a hard case to quantify, right? Well, what's the family dog worth? By one metric, it's just, what did you pay for the dog? What does the dog cost? Does the dog have any special training or services that it provides? But for most people, the value of your family dog is that it is priceless to your family. It's an important piece of your family, a member of your family. And so what happened in this case is that the lawyer took that case to trial. The jury awarded a sum of money to the family, but the attorney's fees for litigating that case all the way to trial and winning were hundreds of thousands of dollars. I think almost $200,000 in fees. And that's what incentivizes a lawyer to take a case like that. It's very difficult to place a value on the family's dog, and maybe the jury doesn't put that much money on it. Maybe they only put $5,000 or $10,000 on it. But it's an important principle that law enforcement officers shouldn't execute the family dog in front of the family. And the only way you're going to get any sort of accountability is if you incentivize a lawyer to take that case. Now, these are really difficult cases to win, and the reason is something called qualified immunity. Now, qualified immunity is a judge-made doctrine. It's not in the Constitution. It was created by the Supreme Court. Qualified immunity has two prongs to it. The first is you have to show that there was a constitutional violation, and then you have to show that that constitutional right was clearly established at the time of the violation. And courts can consider either one of these things in order. And what this means is, rather than determine whether there was in fact a constitutional violation, courts will just skip to that other piece and say, well, it wasn't clear that that was the law, or it's not clear that that is the law. And so unless you have a case that is very close to the situation in your case, some prior case that proves that this has been held to be unconstitutional conduct in the past that would serve to place the state actor on notice that they should not have done this in your case. If you can't prove that, then your case will get thrown out under qualified immunity. And because of what I just explained in terms of it's a two-part test, but courts can skip to the second one, it has really arrested the development of constitutional law in this country, because courts are no longer really required to say what the law is on constitutional rights. They can just say whether the law clearly established X as of a certain date. And they don't have to grapple with, well, what about, was there a constitutional violation here on these facts, on this case? And so it kind of slows the whole development of the law and makes it much harder to hold wrongful government actors accountable. There are some proposals to fix qualified immunity, but they are likely not going anywhere under the current government and Supreme Court. So that is going to be the law of the land. This is a prediction, but I think that's the law of the land for a while. The reason qualified immunity is so important, why it matters so much, is that you cannot sue an individual government actor's employer, for example, the police department or the city, for the constitutional violations of that individual actor. You have to show that the governmental entity itself was deliberately indifferent to the risk of the constitutional violation that occurred. What does all that mean? Well, let's take an example like this. If a FedEx driver runs a red light in Memphis, because FedEx, Memphis, and causes an accident, FedEx is on the hook. That's called vicarious liability. If someone is in the course and scope of their employment and commits a negligent act, then the employer is vicariously liable, right? That does not apply in civil rights cases. This is a very important case called Monell. Essentially, you have to prove separately from the constitutional violation by the individual actor, you also have to show some sort of deliberate indifference, direct involvement, failure to train is often an example, by the entity itself. So the mere fact that an officer commits excessive force while in the course and scope of his or her employment is not enough to bring that officer's employing agency into a lawsuit. You'd have to show, for example, a pattern or practice of misconduct, an unconstitutional policy. That is actually how Monell came about, was that there was a facially unconstitutional policy, I believe, relating to pregnancy, rights of pregnant employees. It was basically a discriminatory policy on its face. That almost never exists, actually, in practice. Now, when we say unconstitutional policy, we are referring more often than not to some unofficial policy, a custom or practice, turning a blind eye, for example, to repeated violations by police officers committing excessive force, as an example. So that's why qualified immunity is so tricky, because with the combination of what I just explained with the Monell liability problem, it's very difficult to hold an entity responsible if the officer enjoys qualified immunity or if the officer is protected by qualified immunity. So this video has been an overview of civil rights cases generally. If you want a deeper dive into excessive force cases specifically, check out this older video of ours where we talk in detail about the key Supreme Court case on that issue.